Welcome to the Molding Health Show. Our goal is to leverage the wisdom and experience of healthcare practitioners to set you on a path of self-discovery and healing. These insights, coupled with a multidisciplinary approach to each area of interest, should provide an invaluable resource to everyone looking for a better approach to health. Hi, everyone. So we're going to continue with our practice management course, and Ingrid's ready as well to go through the next module, which is legal considerations. Is that right, Ingrid?
Yes, it is. So with legal considerations, I think often we as healthcare practitioners have all of these HPCSA and ethical guidelines in mind. But the legal considerations of what does it actually take to run a private practice is sometimes, put to the wayside, falls by the wayside. And, what's interesting to note is that even our booklet on ethics has guidelines around our legal considerations. So we're going to start with just having a brief overview from the ethics booklet 4, and that is about how informed consent actually works from a legal perspective. So as you know that, the successful relationships between healthcare practitioners as well as their patients depends on being able to establish rapport or build mutual trust. So that establishment of trust is based on the fact that as healthcare practitioners, we need to respect our patients' autonomy as well as their decision with regards to whether they are comfortable undergoing any kind of medical intervention or therapies. And such a refusal may result in harm to themselves or even cause their own death, but patients still have the right to choose. They do need to be given sufficient information with regards to the condition that they have as well as the treatment plans that is being offered. But we need to make sure that we're breaking down this information in a way that they understand. We can't be using medical jargon, for example, and making it inaccessible. So informed decision comes from the position that, the person understands the information in front of them and they're able to make a decision with taking all of these things into consideration. So the right to informed consent flows from the South African Constitution, the National the National Health Act, and all sorts of other common laws around, as well as the HPCSA guidelines. So healthcare practitioners are expected to be aware of the law in this regard. We can't take informed consent lightly. The law prescribes there's a minimum requirement when seeking informed consent from patients. So just to bring up the perspective of, sometimes you get somebody that comes in and they are not able to give informed consent. And this would be, for example, in the case of minors. You have to have somebody in your space that is able to make an informed decision. You do also have adults that are under supervision or care because of cognitive impairment, for example. Again, it would be the caregivers that would be making informed consent. So there's no getting around informed consent. It's either that you engage with it or you don't. It's not like you as the healthcare practitioner are going to take proxy upon yourself and then make a decision based on what you think is the right way to proceed. Patients have the right to information about their condition, the treatment options that are available to them. So the amount of information that is given will vary depending on, all sorts of different factors. For example, capacity, the complexity of the treatment or the disorder that patient has, the types of treatment. You don't want to give too much of information and frighten the person because they don't have the full context of understanding the medical interventions. So, we need to give enough information to be able to have informed consent, but not bombard or overload patients. Okay. Something else that we must be able to do in terms of seeking informed consent is that we must not exceed the scope of the authority given by the patient, except in an emergency. So what does that actually mean? It means that we can't decide that, I know what's best for you and therefore do this. The only time that, sort of like is an option is if patient is in danger, as in physical harm. So because of that, healthcare practitioners provide treatment and undertaking investigations. They must give patients a clear explanation of why they want to be able to undertake this particular intervention. So you're giving a clear explanation so that the scope of consent is being sought. So it's not just superficial. Yes, please do this, or sign on the dotted line, and they don't really know what they're signing and what they're giving consent to. Healthcare practitioners do need to provide treatment as well as an investigation. Providing the treatment or undertaking the investigation have the responsibility to discuss it with patients and obtain consent. For me personally, best practice would be written consent. I think often, it's easier to be able to get somebody to buy into an idea if you are explaining it verbally. If there is ever an ethical dilemma that comes up, or a case of conduct that gets raised against you, if you don't have informed consent, how do you prove that this was indeed informed consent? So best practice is get it in writing. Okay. As the practitioner will have comprehensive understanding of the procedure and treatment and how it's going to be carried out, you do need to also explain risks to patients. Okay. If this is not practical, then healthcare practitioners may delegate these tasks, provided that they ensure that the person whom they're delegating these tasks to are competent to be able to carry that out. Often doctors will have nursing staff, for example, fill out disclaimers, consent forms before you go in for a procedure. That would be delegation. We also need to determine whether patients who have given informed consent to any proposed investigation or treatment, whether they have actually given informed consent or not. Healthcare practitioners must check how well the patients have understood the details and implications of what is being proposed, and not rely on, well, I have a signature on a piece of paper. Okay, so it is important. Informed consent is a living, breathing thing. It is not just, tick the boxes with regards to paperwork. Healthcare practitioners hold information about patients that are private and sensitive. So how do we protect this? And booklet 5, for example, talks about how do we handle, protect, and provide information about our patients. The National Healthcare Act, that's Act 61 of 2003, provides that this information must not be given to others unless the patient consents, or a healthcare practitioner can justify the disclosure. Again, if patient is in danger, perhaps you can justify. So just to give an example, if somebody other than your patient calls in and says, has this person booked in for a session today? You actually should not disclose that you even know this person, because again, that gives away, the fact, the confidentiality. So practitioners are responsible for ensuring that our clerks, our receptionists, our staff respect confidentiality in performance of their duties. A good guideline is that, even though you have people working for you, ultimately, when it comes to confidentiality, responsibility still lies with practitioner, irrespective of who works for you. And so training of frontline staff, for example, or billing staff is incredibly important with regards to what they actually do with patient information. So these guidelines on when these disclosures may be justifiable is also provided in the book, in booklet number 5. The guidelines on confidentiality are as a result of extensive discussion and debate with various professionals as well as patient groups, and provisions and provide the provisions of the National Healthcare Act. They place responsibility on us as providers or practitioners regarding obtaining informed consent and keeping patients informed about the disclosure of the information concerning them. So, for example, if I have a patient in my care and I know that my patient is also seeing the psychiatrist that I work very closely with, I don't just take it for granted that I can just pick up the phone and speak to a psychiatrist about patient. I need to be able to get informed consent from patient. So, it's my responsibility to do that, rather than patient says, no, you have the right to contact psychiatrist, for example. So the guidelines set out a framework for respecting patient rights and ensuring that information is maintained, information needed to maintain and improve healthcare for individual patients as well as society in general is disclosed to those only who need it for the purposes of helping or assisting patient. Additional duties on healthcare practitioners is to obtain consent, as well as make sure that our data does not identify any one of our patients. Okay. For example, if we go into a practitioner group, a reading group, for example, and we're doing a case presentation, we don't identify our patients. We talk about patient X or patient Y. We have biographical data, but we do not identify that particular patient. So even within the fraternity of healthcare practitioners, we generally guard this information very carefully. The guidelines should ensure privacy-friendly relationships with the patients and practitioners, and they should assist the healthcare practitioners to comply with their ethical and legal obligations. So the guidelines are also based on international ethical codes, the South African Constitution, as I mentioned before, and the National Healthcare Act. Rule 13 of the Ethical Rules of HBCSA states that a practitioner may divulge information regarding a patient only if it's done in the following areas. So in terms of statutory provision, at the instruction of a court, in public interest, with express consent from patient, written consent from parent guardian of a minor under the age of 12, and in the case of a deceased patient, with written consent from next of kin or the executor on the deceased estate. And I don't think, I think often we tend to just take it for granted that we can have consent, only in the therapeutic environment. But these are all of the things that we do need to keep in mind. For example, at the instruction of a court, you cannot say to court this, you can't go and speak to the judge and say patient X. You have to present all of your findings and your notes to court if it is subpoenaed. So what do we want to accomplish by this particular module? I do think it's important to understand when is it that we need an attorney, for example, for legal matters, to understand that not all legal matters need an attorney, to understand that each of the recommended once-off recommended once-off requirements for a practice, and then to also understand each of the ongoing requirements of a functional practice. So when do we need an attorney for legal advice? As much as this seems obvious, is it that we need an attorney with all legal matters? So a disclaimer about this is obviously that I'm not an attorney, and none of these points in this section should be construed as legal advice. It really comes from being in private practice for a while, from life experiences, and certainly just experience with regards to running private practice and what I have encountered. But for the most things, some level of sense should actually prevail. You're not going to be running off to your attorney at the drop of a hat. For example, if you have a headache, here's the recommendation is that you perhaps need an appointment to see a doctor if there's an ongoing recurrence of a headache. But you can also self-medicate. You can have 2 Panado from the convenience store and it'll work just as well. So we would only see a doctor if the headache persists indefinitely. So in the same way, it's important to point out that this section shows or highlights some of the legal aspects that you need to consider for your private practice. But the onus is upon you as a practice owner to figure out which one, how each of these situations should be handled in terms of, do we need expert advice from an attorney, or are we able to get away with, for example, contacting colleagues, speaking to an ethics line, for example, as we established in our previous module, or, just being able to brainstorm with colleagues, trusted colleagues around you. So I'll be categorizing each of these legal requirements into either once-off requirements or ongoing requirements. Let's start with the once-off requirements. And, right at the beginning of before we even consider practice, and whether that is clinical work or private practice, we start off by getting our registration done with HPCSA. These days, the registration with HPCSA is only applicable if you have fulfilled all of the requirements of your degree. And that, for example, it differs per different categories of healthcare practitioners. But each of us have minimum requirements in terms of the degrees that we've had in order to be able to become professionals. So, for example, with psychologists, we have to complete the minimum requirements as per university for our master's degree in psychology, whether we're counseling, educational, or clinical. And at the end of that, we also need to write a board exam in terms of ethical guidelines before we can actually start thinking about registration with HPCSA. So minimum requirements as per university initially. Once all of that is done, then you can go off to HPCSA with your portfolio of evidence that you have fulfilled all of these requirements, and you're then given an opportunity to register. When you register with HPCSA, you receive your HPCSA number. It's important to note that each HPCSA number that we receive denotes the practice that we have, or the discipline that we have, that in terms of what we're providing service for to the public. So, for example, you have some people that may be that may have two HPCSA numbers. So you might be an occupational therapist as well as a psychologist, and they would be registered to two different boards. The number that would be applicable would indicate the service that you have offered to patient, and that comes from the codes that we use. So it's important to be able to take note of HPCSA number only comes into play once you have fulfilled all of university requirements. Okay. Another important registration is what we would require if you wanted to go into private practice. And this is our BHF numbers, which gives us our practice numbers. It's important to note that people that work, or healthcare practitioners that work in state, do not have to have a BHF number. And the reason for that is your hospital has a practice number, and generally we fall under the practice number of the hospital. But if you wanted to go into private practice, you need this number. They will ask for your HPCSA documentation, and then you apply for a practice number. It is generally given to you quite quickly. And once this is done, your personal details and data is also shared with each of the medical aids in the country. As much as this is, done by BHF, you find that most of the medical aids in South Africa are also going to ask you to register with them, because they have their own minimum requirements as well. So why do we need to register with BHF and obtain a practice number? If you want to go into private practice and you want to be able to either submit a claim to medical aid yourself, or give your patient an invoice that they can submit onto medical aid for reimbursement, you need a practice number. Our practice numbers are locked into our disciplines or our professions and cannot be used in another profession. So as a psychologist, I cannot bill as a physiotherapist, for example. BHF also gives us these, what they call tariff codes. And the tariff codes are an indication of what kind of treatment you have offered patients in the therapeutic space. So once you have your practice number, you are able to submit these claims to medical aids, and your patients may then receive reimbursements. Each medical aid has their own requirements, as I've said before, together with forms and methods of registering with them. So it's best to be able to contact them and find out what the process is in terms of registering yourself. Most often than not, I find in private practice, this is really just about reimbursement to us if we're submitting on behalf of client. So effectively what they're looking for are your banking details. And you do need to prove that it's an active, valid banking account. If you're deciding to trade as a sole proprietor, there's no real registration that is needed from a company structure point of view. If you want to trade as an incorporation, on the other hand, you would need to register with CIPC. Most accountants or business consultants will be able to assist you with this. Generally, if you are spending about more than 800 Rand for a registration like this, it's probably too much, and you should actually look for alternatives. One of requirements would be that we would have to create a bank account. It should be noted that your bank account for your private practice shouldn't be your personal bank account. There should be a separation between personal stuff and practice stuff. So there shouldn't be any income or expenses on your private practice, for your private practice on your personal bank account. So if you're trading as a sole proprietor, you want to open up a separate business account at a bank of your choice. You would probably need your South African ID and proof of residence to get this done. If you're trading as an Inc., you would probably need your CIPC documents as well as ID and proof of residence. In terms of registering with medical aids, once you have your practice number, as I mentioned before, each medical aid is different. They would require you to prove that you have an active, valid bank account as part of their registration process. So it's best to be able to either call them or visit their websites and find out what the process is with them. Once you've done that, you are then able to submit claims to them. So even though you don't intend to submit claims to them, and you just want to have a private practice with private rates, it's still a good idea to have this done. In the event that your patients want to submit these claims, you would need to meet these minimum requirements. Also, with regards to registering with medical aids, in terms of your supporting information, you need to understand that medical aids and medical aid administrations, the administrators, there are more than 90 medical aids in South Africa, but there are less than 20 medical aid administrators. So medical aids such as Discovery do their own administration. And, actually, Discovery is taken on other medical aids as an administrator. So I think they have about 20 to 25 different schemes that they administer at the moment. So when you're doing these registrations, sometimes you just do it with the administrator rather than each medical aid scheme. In our experience, the administrators would be, for example, Discovery, Bonitas, CAMAF, Metropolitan, and GEMS. You would also need the bank account details for the private practice. So once you've set up your private practice, you would also want to rent out premises, for example. So getting a lease agreement in place with getting a lease agreement in terms of the practice is possibly a once-off. Your landlord might be very good at this, and they would offer you various options. Our recommendation is to initially get a shorter lease rather than a longer one, preferably about 6 months long, with an option to renew. And the thinking behind this is you want to, especially if you're going into a practice that you don't really know well, a geographical area that you don't really know well, you want to try it out for a bit to see whether this is a place that you can settle, and that your patients are comfortable, and it becomes a good working space for you. If you're locked into a long lease, it's very difficult to leave. So although your landlord might want to tempt you into having a longer lease, really consider at the beginning, try out the space for at least 6 months before you go into a longer lease. Okay, the flexibility of this will allow you to figure out whether this works for your private practice. I'll give an example. I mean, I once had premises in dental surgery. I don't know what I was thinking at that time, really. I'll put it down to, I was young and naive. And I had a chiropractor that had rooms right next to mine. And as a psychologist, you generally use the talking method. And, in the midst of a session, for example, you would hear his patients scream or groan because of the adjustments. And after a while, I figured out, well, this is not going to work for me. It made my anxious clients really, really anxious because they could hear other people, and they would often wonder about the levels of distress. So you do want to try it out for a little bit. If it works for you, you can always renew. Okay, in our experience, the average monthly lease amount should be approximately 6,000 to 12,000 per month. I think anything more than that, unless you're renting out a space entirely for yourself, is going to be exorbitant. A separate idea that as you progress in your private practice, is to rent out a premises with other practitioners and then split the rental equally between the two of you. You can set up a holding company, for example, have shared expenses in the holding company, and then, run private practice as a sole proprietor. This is more cost effective because you're sharing the expenses. And it can involve more work on the part of everyone involved, maintaining and running the practice efficiently. If you're ever considering this option, it's important to speak to a coach in detail and find out which company structure you should be using. So should it be an incorporation? Remember that an incorporation can only be with practitioners. So for example, I would only be able to set up an incorporation with other psychologists. I won't be able to have a multidisciplinary team. If it were a multidisciplinary team, you would have to have a different structure. And then we come to tax registrations. As mentioned before, in terms of company structure, you need to run private practice. If you're running private practice as a sole proprietor, it's much easier. One of the areas in which this is shown quite clearly is the tax compliance aspect. So in terms of being a sole prop, you would need to complete the following SARS registrations in your personal capacity. So the first one would be your registration for an income tax number. 2 would be registration as a provisional taxpayer. Generally, provisional tax is paid twice in the year. If your practice is making an income of more than R1 million, then you would also have to register for VAT. And if you have employees in your practice, then you would have to register for employer tax. As an incorporation, you would need to complete the following registrations for SARS in the name of the incorporation. So income tax number, registration for VAT, again, if incorporation is making more than R1 million, and registration for employer tax if you have employees. For every employee, locum or supplier that you have in place, you should have the necessary contracts. You should have predefined contracts as per our tools and resources module. But if you should ensure that these contracts comply with the HPCSA rules. I think at this point, it's also important to note that you can have a legal agreement drawn up, but as healthcare practitioners, our HPCSA ethical guidelines will always trump any other legal agreement that we have with regards to private practice and the way that we treat our patients. But if you're not sure, spending money with an attorney in order to be able to review related contracts is definitely a good idea and possibly worth the time, energy, and effort and money. Employee and supplier contracts. So with all of the documents, you need to make sure that a document is signed correctly. That is, that the relevant people that are signing the contracts are witnessed, as well as having signatures and initials on every page. It's important to keep the signed contracts in a safe space for reference and scan contracts so that you can secure them online that are password protected as well. So if there is any kind of discrepancy that comes up, you always have it as a point of reference. With the increasing prevalence of theft, it's very easy for you to lose important documents such as these. And the legal ramifications of not having contracts in place or not being able to prove that you had one could be very costly. So website disclaimers and privacy policies is also quite an important aspect when you're setting up your website. There are many policies that you need to put into place for people that are visiting your website, and most of these are similar, but you can find out how to do this in our tools and resources module. To comply with this requirement, just ensure the necessary documents are on your website and are easily accessible. Some of these are your website terms and conditions, for example, your privacy policy, and how your practice actually manages papaya. Our patient intake forms and agreements. Every patient or client that comes in to see you should actually complete and sign an intake form and an agreement on, and there's informed consent on the agreement on how you're going to be conducting the therapy in your private practice. So some of our recommendations around the information you need are full details, your biographical data of patients, so full details of patients, full details of the person responsible for the account, work details of the person responsible for the account, and 2 next of kin contact details in full. The client agreement details all of the information related to how the patient will be dealt with in your private practice. Some critical aspects must be included are: how will you be doing the invoicing? The rates of your various therapy sessions? When do you expect your payment? So your payment terms. How will you treat overdue accounts? How will you store the information, which is very important in terms of papaya? And if you're using external service providers, you should actually put that as a disclaimer on your intake forms, because there are other people that are exposed to their details. So how do we do the invoicing? Invoices for healthcare practitioners are slightly different to other invoices that you might see for businesses, such as consultants or plumbers. For example, you need to include medical aid information for client, the ICD-10 code for client, BHF codes for our practice sessions. In some disciplines and therapy sessions, you might even have to include referring practitioner details. A sidebar on this is your invoices should also, if you have a practice where there's more than one practitioner, like for example, with an Inc., your invoice should indicate who is the attending professional as well. For this reason, most of the accounting softwares are not necessarily a perfect fit for healthcare practitioners. They can work, but it's more like a duct tape sort of approach. So if you want to find out more about practice management software and which one will be a best fit for you, there are many options out there at the moment. And really what you want to be able to have is ease of billing and submission to medical aid claims, the claims to medical aids. Another key point in terms of invoices is to not write out your invoices manually. And certainly do not generate your invoices on Word or Excel. Yes, it works, but again, it's not a great fit, and it can also be very easily changed. During our presentations to healthcare practitioners, one practitioner mentioned that she used Word for her invoices, and she wasn't even converting them to PDF documents. And this means that, client could change the invoice and submit it to their medical aids for personal reimbursements for therapy sessions that they didn't attend. So we don't want to be caught up in defrauding medical aid simply because we were, not careful with the way that we presented our invoices. And yes, this is fraudulent on the part of clients, but ultimately at the end of the day, negligence and unethical behavior the responsibility of a proper invoice comes right back to us as practitioners. Perhaps 10 or 20 years ago, this would have been acceptable in terms of handwritten or Word or Excel documents. But, with technological advances as well as information and knowledge freely available to all practitioners at the moment, I really would argue that you would be on shaky ground if your private practice is starting out or you are maintaining a very busy private practice and you're handwriting and you have no way of tracking the invoices that you have issued. The other thing that just springs to mind is with Word and Excel, I would hate to think about where storage would be for each client. What do you create little folders on your computer? And then again, from a papaya point of view, how do you password protect all of those things? It just becomes an absolute nightmare. Okay, and then we move on to financial statements. So part of being a business owner and a taxpayer is the financial compliance that we have for your business. So without proper financial statements or an accurate financial view on your private practice, you cannot accurately fulfill your tax requirements. So these are serious legal and financial consequences for non-compliance on tax aspects. So it's important that you either do this function yourself or you get your financial statements in order. Or you can pay relevant practitioners or consultants to do this for you. Fortunately, there are very simple accounting packages that can help with this process. CIPC submissions, if, again, you're running private practice as an Inc., there needs to be an annual return submission that is done. If you don't submit your annual returns, generally CIPC will automatically deregister your Inc. Without your CIPC registration for your Inc., the Inc. will not exist, and by implication, your private practice will not exist. So this has a huge implication. It's important that you either do this function yourself or you get your CIPC compliance in order, or you pay relevant consultants or professionals to do this for you. SARS submissions. As a business owner and taxpayer, there are certain SARS requirements that need to be completed. If you don't complete these submissions, legal and financial consequences from SARS in the form of fines or possible imprisonment is indicated. So non-compliance from a SARS perspective is a criminal offense. And then we go right back to what we talked about in module 1 with regards to, private practice or healthcare is as a profession is a moral, we need to take a moral perspective from on that in terms of making sure that, we're far away from doing anything that is considered criminal activity. So it's important yet again that we either do this function ourselves or to get our SARS compliance right, or we have relevant consultants or professionals to do it for us. So examples of SARS submissions that you would need to be aware of. So sole proprietors would have income tax returns, provisional tax returns, the interim and the final, EMP 201s. These submissions, if you have employees, your EMP 501 submissions, if you have employees as well, and then your VAT 201 submissions if you're VAT registered. So if you are an Inc., the tax submissions then need to be done in your personal capacity as well as for the Inc. One last item to consider is that if you're non-compliant from a tax perspective and have serious tax issues with SARS, are you acting ethically, and will HPCSA have good grounds to investigate you further? Although there's no HPCSA ruling on this just yet, and no precedent to my knowledge, I can mention that if you have a criminal record, you cannot be registered as an attorney or a director of any company. So, coming back to your Inc., you're going to be in breach. Ongoing requirements would be, for a functional practice that is submitting to medical aid, it would be your medical aid claims. So if you're going to be submitting claims to medical aid so that they can pay you on behalf of your client, which is certainly a good idea, because what this does is it gives you a quite stable cash flow for your practice. But again, it does have risks. There are non-payments from medical aids, and it is obviously a lot of work for you. So you have two options when it comes to medical aid claims. You can simply send an email to medical aid with your invoice, or you could submit through what we call EDI, which is an electronic submission to medical aids. If you wish to use the EDI submission option, you can do this using practice management software, which has this feature. So many years ago, the only option to submit claims to medical aid was the EDI option. However, this has changed significantly over the last 5 to 10 years. In simple terms, it's just two different ways of getting to the same destination. So you can either use a bus or a car, for example, to get to your destination. The bus might be cheaper, but not everybody wants to use the car or has possibly access to a car. So benefits of using email-based option is that it's free. It doesn't cost anything to send an email. The disadvantage is that it slows down the process of being paid. Whereas when your invoice is submitted electronically, with the email submission, the invoice has to be processed by a data capturer, and they can make mistakes, and so you might have to resubmit. The benefits of EDI is that it's faster to get paid by medical aids, and it's less prone to mistakes. For example, with Discovery, they generally do a payment run once a week. And so if you have Discovery Health claims or any of their medical aids that you are submitting these claims, you generally would get a payment into your practice once a week. However, the cost implication for each claim submitted, there is a cost implication for each claim submitted, and this could be either a fixed cost or it could be a percentage of the claim. My recommendation is that you try it both to your medical aid claim submissions and see which one makes more sense for you. There's the email-based claim, which might make financial sense, but you could consider the negligible costs when it comes to EDI claims as compared to your total invoice value. So, in my experience, I find that EDI certainly, stabilizes cash flow, like I said, and it makes follow-ups with medical aid quick and easy as well. Following up with overdue invoices and debt recovery. So not all invoices are going to be paid by your clients. It doesn't mean that we haven't done the work, but this is unfortunately the scenario. In our experience, it's as high as 5 to 20% of all invoices that are not paid in private practice. This obviously puts your private practice at risk, because you're dependent on that cash flow coming in. So if you're dealing with medical aid payments, and the scenario for unpaid will be a normal challenge in your private practice, you should absolutely expect that not all of your invoices are going to be paid. So it's important for you to consider that you will have to follow up on overdue invoices. And when you're doing this, most businesses have a policy of sending out reminders after 30 or 60 days. A key consideration around this is whether you actually want to do this function yourself, and whether you can. Not many people, and definitely not healthcare practitioners in our experience, have the stomach to call people and demand payment. It complicates the therapeutic relationship. And it makes it very uncomfortable with regards to, constantly asking for this payment, and if it's not coming. So the goal is to be, this goal is almost impossible if you're calling your clients over their overdue invoices. So what are our options? We can have an outsourced management, a practice management service, an outsourced unpaid management service, or we could actually make use of a debt collector. Following up on undue invoices and debt recovery, here are a few recommendations for debt collection. So most certainly they should use a soft approach when it comes to unpaids and in the follow-up process. You don't want to absolutely ruin the therapeutic relationship between you and your patient. And so to be able to send out gentle reminders, or a phone call, or a message, is possibly a good way of keeping the therapeutic relationship intact. We are most certainly not allowed to blacklist any clients for non-payments according to the latest HPCSA rules that we have at hand. And this is the favorite weapon of most debt collectors, but it's not one that we can use as healthcare practitioners. So we do need to make sure that the company or the person that we choose to do this understands these limitations. Why does this rule make sense? It's because blacklisting the person puts them onto the public directory with your name attached to theirs. So in terms of the judgment. So this links you with patient, and it is a contravention of our patient practitioner confidentiality. Something else that might be of interest, and certainly for consideration, is, do we send out reminders for each therapeutic session? So if you want to reduce your chances of missed appointments, with our complicated and busy lives, people generally tend to forget their appointments. So an easy way to remind them about the appointments, having to find an easy way to remind them about their appointments is a necessary part of private practice. There are practitioners out there that will say that it's not part of the therapeutic process, and it is the responsibility of patients to remember their appointments. But it's up to you as a practitioner as to whether you would like to use this function or not. You could do this by sending them an email or an SMS manually. This approach would certainly work. Or you can also use an appointment scheduling software, or check if your practice management software has this feature available to you. So one note about this is that you have to make sure that you have permission to send out these appointment reminders to patients. You can include them in your standard client agreements when they sign up with you before they start up therapy. And that concludes our sessions.
That was amazing, Ingrid. Again, good session. I just want to say something about the EDI submissions. And I think for many years, there was not too much of a difference between them. But in the last year, we've noticed a significant difference between them in terms of performance. And I think if you do choose to use email-based submissions, just make sure that you're phoning medical aid and really hounding them and keeping up to date.
Absolutely.
Because there's a huge delay, between those two options. So I think just bear that in mind. So any software that you pick, make sure that you do have both the options. And as you clearly said in the presentation, you want to go with or want to really consider the EDI approach. But thanks again. That was amazing.
Pleasure.
Hey, everyone. Thanks for listening. As always, stay tuned and we'll speak to you in the next episode.